Have you ever looked at a rental agreement and seen the word license instead of lease? You might think, what's in a name? But in the eyes of the law, that name can be a massive clue or a massive misdirection. Today, we're going full-on detective to figure out the truth behind these agreements. Because as you're about to see, what a document is called is often just a clever disguise for what it really is.
So here's our roadmap, our case file for today. First, we'll get to the bottom of why this whole thing even matters, the big, and I mean big, difference between a lease and a license. Then we'll grab our detective's toolkit, a 3-part test that the courts use. We'll look at some real-life cases where judges saw right through some clever tricks. We'll even tackle what happens when it's a group of you signing. And finally, we're going to put it all together to solve a case ourselves. Let's get to it. All right, first things first, why all the fuss? Well, whether you have a lease or a license is everything. It's the difference between having a strong legal shield protecting your right to live in your home and just having simple permission to be there, permission that can be taken away a whole lot easier.
Okay, so picture this. You've got 2 documents in front of you. One says lease, the other says license. They both let you live somewhere, you pay for both. On the surface, they seem kind of the same, right? But in legal terms, they are worlds apart. So what is the real fundamental difference? Let's break it down.
Here it is, the absolute heart of the matter. A lease gives you what's called a proprietary right. Now that's a fancy term, but it basically means you have a real stake, a legal interest in the property itself. It's protected by some serious laws, and if your landlord sells the place, your lease carries on with the new owner. A license, on the other hand, that's just a personal right. It's like a ticket to the movies. It lets you use the space, but it doesn't give you any real rights in the space, and it can be revoked way more easily. So how do we actually tell them apart? How do we see through a potential disguise? This is where we get our official detective's toolkit, and it comes to us from a huge, game-changing court case called Street versus Mountford. And here is our golden rule, straight from that very case. The judge, Lord Templeman, said the court has to find the true bargain. In other words, you totally ignore the label. An agreement can shout, "I am a license," in big, bold letters, but the court will look past the form, the label, and dig for the substance, the reality of the situation. So our rental toolkit helps us find 3 essential clues. If you can prove these 3 things exist, you've almost certainly got a lease, no matter what it's called. Number 1, and this is the big one, exclusive possession. That's the right to lock the door and keep everyone out, including the landlord. Number 2, a term certain. There has to be a clear start and end date, or a rolling period, like month to month. And number 3, rent. Pretty straightforward. You have to be paying for it. Okay, we've got the toolkit. Let's see how it works in the real world. We're now cracking open some old case files to see how judges used this exact 3-part test to uncover the truth. First up, this fascinating case. The form was 2 totally separate lease agreements given to a couple for a small 1-bedroom flat. But the substance? The court said, no way. These 2 documents are obviously linked. You have to read them as one. The landlord also put in a clause saying he could move in or put someone else in there with them. The court called this a pretense, a total sham. The flat was tiny. It was an unrealistic clause just to avoid creating a lease. Verdict? It was a lease. Now have a look at this one. The agreement said the person living there had to leave the room for 90 minutes every single day. Seriously. The landlord also held on to a set of keys. But again, the court looked at the substance. That 90-minute rule, it was an absurd pretense that was never, ever actually done. And the keys? The court pointed out that landlords keeping keys for emergencies is normal. It doesn't automatically kill a lease. So once again, the verdict was clear. It was a lease. Okay, so we've seen how it works for one person, or a couple. But what about a group of people? Like in a student house? Well, for a whole group to have a single lease together, they have to clear an extra hurdle. They need to have what the law calls a joint tenancy. And to get a joint tenancy, you have to pass this 4-part test. They call them the 4 unities. Think of it like a 4-piece puzzle, and you need every single piece to fit. First, title. Everyone signed the same agreement. Second, time. Everyone moved in at the same time. Third, interest. Everyone is on the hook for the whole rent, not just their share. And fourth, possession. Everyone has the right to use the whole property. If even one of those is missing, the puzzle isn't complete, and it's not a joint tenancy. All right, detective, you've got the toolkit. You've studied the classic cases. Now it's your turn. We've got one final case to solve for a couple named Bob and Kathy. Let's see what you've learned. Here are the facts of the case. Pay close attention. Bob and Kathy, a married couple, find a one-bedroom flat. The agreement they're handed says license right at the top. It says they have to pay a monthly license fee. And, surprise, surprise, there's a clause in there that says the landlord can move a relative in to live with them. The investigation begins now.
Okay, let's pull out our three-part test. We'll start with the two easiest clues to spot. Is there a term certain, and is there a rent?
And the answer here is a big yes to both. By paying monthly, they create a rolling monthly term. So check, we have a term certain. And that license fee, we know from our golden rule to ignore the label. It's money for accommodation. It's rent. Check. That's 2 out of 3 clues locked in.
And now for the main event. This is usually the one where the whole case cracks wide open. Does that little clause, the one about the landlord's relative moving in, actually destroy their claim to exclusive possession?
Well, let's think back to our case files. This sounds awfully familiar, doesn't it? A one-bedroom flat advertised for a couple. The idea of a third person just moving in is ridiculous. It's a classic pretense, just like we saw in that Antoniadis case. It's a sham clause, pure and simple, and the court would almost certainly ignore it.
We are so close. But wait, there are 2 of them. So we have to run that final check. Do Bob and Kathy pass the 4 unities test for a joint tenancy?
Let's run the checklist. Are they signing the same document? Yes. Do their rights start at the same time? Yes. Are they both on the hook for the full £1,000? Yes. And do they both have the right to use the whole flat? Absolutely. It's a clean sweep. All 4 unities are present and correct. And with that, this case is officially solved. We looked past the misleading label, we applied our tests, and we found that the substance of this agreement grants Bob and Kathy a lease. They are joint tenants, and they have all the legal protections that come with that.
Which leaves us with one last really important thought. The law cares about the reality of your living situation, not just the words printed on a piece of paper. It's there to see through the disguises. So maybe it's worth taking another look at the agreement you signed. After what we've uncovered today, is it really what you think it is?